In this lecture, we're going to focus on private discrimination, and that is discrimination by non-governmental agents. Now, in most of your work as a public manager, it's public discrimination that will be most relevant to you because, of course, most of you will work for public agencies, but many of you will not. Many of you may work for nonprofit organizations, you may work for interest groups or lobbying organizations or even labor unions, and these are all private organizations that would not be covered under what we've already discussed. So, in order to understand the law of private discrimination, it's important to understand the state action doctrine that was formulated by the Supreme Court. We already know that the 14th Amendment and the Equal Protection Clause were added to the Constitution in 1868. Well, a few years after that, in 1875, Congress passed a law banning private racial discrimination. It banned discrimination in various kinds of businesses, including theaters, inns, like motels, although they didn't have motels, but inns, places of public amusement, so on and so forth. And so it was an attempt to provide some level of equality between the races in the provision of private services. But that did not last long, because in 1883, the United States Supreme Court struck down this Civil Rights Act of 1875 in a case known as the Civil Rights Cases. It's a little confusing. It's only one case called the Civil Rights Cases. Don't worry about it. But they declared the law to be unconstitutional. Now, why would this law be unconstitutional? Well, the reason that they said was that the Constitution did not give Congress the authority to pass that legislation. If you recall from our discussion of federalism, the Congress can only do those things that it's given the ability to through the Constitution. And the 14th Amendment does provide equal protection, but according to the Supreme Court, the 14th Amendment only applies to government action. If you'll recall, the Equal Protection Clause begins by saying, "No state shall deny to any person the equal protection of the laws." And the Supreme Court interpreted that to mean that the 14th Amendment only applies to governmental discrimination. It doesn't apply to private discrimination, and therefore Congress has no power to ban it. And this is what became known as the State Action Doctrine. Under the State Action Doctrine, only state action was prohibited by the 14th Amendment. Non-state action was not touched. Now, of course, under federalism, this left an interesting conundrum. According to the Supreme Court, the federal government had no power to ban private discrimination. Under our system of federalism, state governments did have the power to ban private discrimination because this would fall under their general police powers. But of course, it was many of the states, particularly in the South, that had no interest in banning private discrimination. In fact, they had an interest in encouraging it. So we reached a point where private discrimination essentially continued unabated. Now, the State Action Doctrine, things have certainly changed a lot since then, but the State Action Doctrine has never been overturned. So one of the things that we have to figure out is, why do we today have laws that ban private discrimination, even though the State Action Doctrine's never been overturned? Well, the answer to that question rests with the passage of the Civil Rights Act in 1964. Almost 100 years after the passage of the Civil Rights Act of 1875, Congress did it again. They passed a new Civil Rights Act, the Civil Rights Act of 1874, which banned racial and gender discrimination in both the public and private spheres. So although it did apply to public discrimination, it also applied to private discrimination. And of course, this also applies to state agencies as well. And as I just mentioned, it includes not only race, but it included gender as well. So in many ways, the Civil Rights Act of 1864 was very similar to the Civil Rights Act of 1875 in that both of them touched private discrimination. But of course, the original act was unconstitutional. So the question then, of course, would be, is the Civil Rights Act of 1875 of 64 constitutional? If the earlier act was unconstitutional, why isn't this one unconstitutional? Well, the Supreme Court decided a challenge to this law very quickly in a famous case called Heart of Atlanta Motel v. U.S. from 1964. This is the Heart of Atlanta Motel, and as you can imagine, it had white owners, and it wanted to maintain a whites-only clientele. And it therefore sued, claiming that the Civil Rights Act of 1964 was unconstitutional for the same reason that the Civil Rights Act of 1875 was unconstitutional, and that is that the federal government had no power under the state action doctrine to ban private racial discrimination. But in this case, the court upheld the law, and it upheld it unanimously. So the interesting thing is that the Heart of Atlanta Motel was not decided under the Equal Protection Clause. They did not have to go back and overturn the state action doctrine because they decided that they didn't have to consider whether the Equal Protection Clause gave Congress the power to ban private racial discrimination. Rather, they relied on our old friend that we remember from earlier in the semester, the Interstate Commerce Clause. The Constitution gives Congress the power to regulate interstate commerce, and these laws, the Civil Rights Act of 1964, regulated interstate commerce, and the court therefore said it was constitutional. So they simply found a new part of the Constitution, or rather a very old part of the Constitution, to justify this particular law. So let's take a look at the Civil Rights Act of 1964 and quickly take a look at its key provisions, because some of you may be writing your papers on cases having to do with the Civil Rights Act of 1964. The titles that you as a public manager would be most interested in are Title II, which involves public accommodations. Now this is a little confusing because we've been using the term public in this case to mean governmental. In this instance, public simply means open to the public, so a restaurant or a golf course or something open to the public would fall under Title II. Title III applies specifically to state and municipal governments, so the federal government has indeed passed provisions to govern your behavior as state or municipal employees. Title VI bars federal funding to any government that discriminates. Title VII bars racial and gender discrimination in employment. In addition, the Civil Rights Act authorizes private lawsuits. Before 1964, individuals could not bring suit in federal court if they had been discriminated against. But since 1964, individuals now are authorized to bring lawsuits in federal court to enforce these provisions of the Civil Rights Act. The law also allows the Equal Employment Opportunity Commission, the federal government itself, to bring lawsuits. So institutions that violate the Civil Rights Act can be sued by either the victim or by the federal government in the guise of the EEOC. Now, before somebody can file a lawsuit, they have to file a complaint with the EEOC. The EEOC likes to monitor what's going on, so they kind of act as a clearinghouse. So that's another provision. Regardless of where you wind up after your graduation from the MPA program, there's one provision of the Civil Rights Act that will be relevant to all of you, and that's Title VII, the employment provision, which applies to both public and private employees. Title VII lawsuits tend to follow a very predictable pattern. In order to be able to bring a Title VII lawsuit, an employee has to allege that they suffered some negative job-related action due to their race or to their gender. And a negative job-related action could include being fired, being demoted, being transferred, having your hours cut back, being not hired in the first place, being paid less than your colleagues, or any number of other negative job-related actions. If this is alleged and the lawsuit goes forward, the employer then has to demonstrate that there was another non-racial or non-gender reason for the job-related action. And Title VII lawsuits often turn out to be quite nasty because typically the only other reason that an employer can offer for why they fired or otherwise took negative actions against an employee was usually because the employee was no good. And so employees who bring Title VII lawsuits have to be prepared for a trial in which they will be the subject of character assassination, and that the employer will attempt to prove that they were not a good employee. So these are uncomfortable lawsuits to pursue, typically. Now, we've mentioned that when the Civil Rights Act of 1964 was passed, it included race and it included gender. But over time, ever since the Supreme Court upheld the right of the Congress to pass anti-discrimination legislation, it has passed several other laws protecting other groups against discrimination. Now please notice that a lot of these are groups that are not protected under the Equal Protection Clause. We mentioned that the Supreme Court has only decided that a certain small number of groups receive the protection of the Equal Protection Clause and are suspect classes. But even if the Supreme Court the Constitution doesn't protect those groups, Congress can step in and provide more protections than the Constitution does. It can't provide fewer protections, but it can provide more protections. And so, for example, Congress has passed the Age Discrimination in Employment Act. As we mentioned, age is not a suspect class. Governments can make distinctions among people based on age, but according to the Age Discrimination in Employment Act, employers cannot discriminate against employees who are over the age of 40. Now, this is narrow, of course. It only protects employees over the age of 40, and it only applies to employment. But nevertheless, age discrimination in this context is prohibited. In addition, Title IX was passed in 1972. These were the education amendments to Civil Rights Act of 1964, and these are primarily known for expanding gender equity in college sports. And so many universities have expanded their women's sports offerings to achieve parity with men as a result of Title IX requirements. There's also a law known as the Pregnancy Discrimination Act of 1978. This prohibits employers from discriminating against individuals on the basis of their pregnancy status. And this was used a few years later by an actress who was hired to play a role on Beverly Hills 90210. She was hired to play a sexy vamp who was going to flirt with many of the people living at Beverly Hills 90210. And after she was hired, she got pregnant. She was then fired because the producers said that she couldn't adequately play a sexy vamp. She filed a lawsuit under the Pregnancy Discrimination Act, which she won because the court said that the production company could have taken steps to conceal her pregnancy status, and that by firing her they did indeed violate this law. You've also got the Equal Pay Act, which was passed in 1963. In fact, this even predates the Civil Rights Act of 1964, which mandates equal pay on the basis of gender. One of the more recent anti-discrimination laws was the Genetic Information Non-Discrimination Act, meaning individuals and employers cannot discriminate against you on the basis of your genetic information, knowing, for example, whether you may be more predisposed to get a certain disease or not. Companies cannot act on that information. And of course, one of the most famous of the other anti-discrimination laws is the Americans with Disabilities Act, which was passed in 1991. We're going to talk more about the Americans with Disabilities Act in a moment because it may be relevant to you as a public manager. But one question that I want to talk about before we do that is, what about LGBTQ rights? The interesting thing is they are not covered by any specific law. They're not covered in the Civil Rights Act of 1964. No specific federal law has been covered to guarantee that they are not discriminated against at the federal level like those other groups. However, many lower courts have interpreted the Civil Rights Act banning of discrimination based on gender or because of sex as also covering LGBTQ rights. There's been conflict, though, among the lower courts, and this is a question that we will soon know the answer to, because right now, as I speak, there are currently 2 cases before the United States Supreme Court that they will decide before the end of their term in June. So sometime within the next 3 months, they're going to hand down decisions in these 2 cases. One involves the question of whether the Civil Rights Act prohibition of discrimination because of sex includes discrimination based on sexual orientation, and the other asks the question of whether it bans discrimination based on transgender status. So it'll be very interesting to see the outcome of these cases. I suspect, like most things we'll see happening over the next few years, it will probably be a couple of 5-4 decisions in which the court finds that these 2 groups are not protected. But we will finally know once and for all whether they're protected or not by this coming June. Let's talk for a few moments about the Americans with Disabilities Act, because this is one that as a public manager you may need to avail yourself of if you ever find yourself disabled, and of course you need to be aware of it as you provide services or in your position as a manager of other individuals. So the ADA, let's talk a little bit about eligibility. In order to bring an ADA lawsuit or file an ADA claim or be eligible for benefits under the ADA, the plaintiff, first of all, has to prove that they have a disability. A disability is defined under the law as a physical or mental impairment that substantially limits one or more major life activities. And major life activities, of course, are things like eating, walking, sleeping, going to the bathroom, having sex would also be included, seeing, so on and so forth. You can imagine a list of others. And so not only does the plaintiff must prove that they have a disability, they have to be able to prove that they were excluded from participating in or they were denied the benefits of a service or a program as a result of their disability. So that they were turned down for something or received some sort of disadvantage as a result of their disability. And again, it has to be due to their disability. It can't just be because they were obnoxious or something like they were drunk or something like that. The exclusion has to be because they were disabled. Now, employment is the section, again, that will be most useful to you as public managers. And of course, the Americans with Disabilities Act covers both aspects of your job, both your aspect as an employee and your role as a delivery, as a service delivery mechanism. But let's talk about employment. One of the things that I think a lot of people are mistaken about is that the Americans with Disabilities Act does not guarantee anybody a job for which they're not qualified. In order to get a job under the Americans with Disabilities Act, you have to be qualified. So blind people cannot apply or cannot expect to be hired as bus drivers. That is not what the Americans with Disabilities Act is all about. Individuals must have the skills and experience to meet the essential functions of the job. Now that has become very contentious. What are the essential functions of the job? And just to talk about an interesting case having to do with this particular question, back in the 1990s, there was a professional golfer named Casey Martin who had a disability that didn't allow him to walk far distances, and he needed to use a golf cart when he participated in golf tournaments. The PGA tournament would not allow him to do that in their higher ranked tournaments because it was against the rules, and they argued that they did not have to make an accommodation to him under the Americans with Disabilities Act because walking was part of the essential function of the job. And so in a very interesting case, the Supreme Court was called upon to decide whether walking from hole to hole is part of the essential function of the job of a golfer. And ultimately they decided that it was not, that the essence of golf is shot making and doesn't include the walking. Now others on the court disagreed and said, well, wait a minute, now walking can lead to fatigue, which can affect your shot making, and so that is part of the essential function of a golfer. But this is a great case because it illustrates that it's often difficult to identify what are the essential functions of a job and what are not the essential functions of a job. But if somebody does have the skills and experience to meet the essential functions of a job, the employer must make a reasonable accommodation. Now, of course, that leaves a new question. What is a reasonable accommodation? Well, a reasonable accommodation is one that does not impose an undue hardship on the employer. But of course, what's an undue hardship? I don't think that this definition really helps resolve anything, but those are the terms that are used in the law. Now finally, so far we have focused mainly on federal laws, the Civil Rights Act, the Federal Equal Protection Clause, and so on and so forth. But at this point, it's important to note that the federal government only provides a floor and not a ceiling when it comes to civil rights protections, meaning states can't provide any less protections than the federal government does, but they can provide more protections than the federal government does. And in fact, many states have state anti-discrimination laws that protect groups that are not explicitly protected at the federal level. For example, as we mentioned a few moments ago, there is no federal law that explicitly bans sexual orientation discrimination, but many states have specific laws that do exactly that. And states can add other categories that we haven't even mentioned in any of our lectures here. California, of course, is a classic example. California is an extremely diverse state, it's an extremely progressive state, and the list of groups that receive protection under California civil rights laws is extremely long. Just to take a look at California Government Code section 12920, which relates to employment and housing. This is the part that relates to housing. California law says the practice of discrimination because of race, color, religion, sex, gender, gender identity, gender expression, sexual orientation, marital status, veteran or military status, or genetic information in housing accommodations is declared to be against public policy. So you can see this is a very long, extensive list, and therefore, in your role as a public manager for the state of California, I urge you, don't discriminate against anybody, because you discriminate against anybody, you're probably going to find yourself on the receiving end of a lawsuit. Well, that's it for this topic. That's it for equal protection and civil rights.